Welcome everybody. This is our July event for the British Computing Society Law Specialist Group. My name is Chiara Rustici. I chair the group for this year, and with me are my colleague Nigel, who will be our speaker for tonight, and David, who will be doing Master of Ceremony and introducing the event and the event series. A quick word, we welcome anybody who has an interest in legal aspects and regulatory aspects of IT, of data. We mostly look at producing events to disseminate and inform, but we also have a very strong conversation ongoing with the headquarters and the policy group at BCS. So strong views are welcome. Please join our mailing list so you'll be the first to know about forthcoming events at groups@bcs.uk. Very easy to remember, groups@bcs.uk. And it is now with great pleasure I will hand over to my colleague David Clark to introduce our speaker and our event.
Thanks, Chiara, and a welcome, please, to Dr. Nigel Young, expert witness, expert in intellectual property and computer software, criminal computer forensics, capture, preservation and recovery and interpretation of digital evidence, forensic mathematics, formula and algorithms, and expert at giving mathematical evidence in high-speed security trading case, which kind of sounds highly complex. And I've been lucky enough to see some of the questions that have been coming through, and they are not easy. So it's great pleasure. Yeah, we're going to welcome Dr. Nigel Young, who can be contacted at nigel.young@computer-expert.co.uk. So thank you so much, Nigel. I'm handing over to you.
Thank you very much, David. Well, I've been working in expert witness cases for quite a few years in quite a variety of cases, both civil disputes and criminal cases. As well as being a member of British Computer Society, I'm a fellow and in fact a past chairman of the Academy of Experts, which is a professional body for expert witnesses of all primary professions: construction, accountancy, insurance, medicine, and many others, as well as IT. I have a particular interest in the principles of expert evidence as it's practiced in our common law systems and in variations such as in the European civil law systems. This evening, I want to present an introduction to the role of the expert witness in IT disputes. I will concentrate on civil disputes, but I will briefly cover the differences with criminal. I'm not going to go any further, but there are plenty of further places I could go into: family courts, to arbitration, courts martial, and many other forms of tribunal. Well, if we're talking about disputes, what might a dispute be about? Well, for example, you might be working for a trustworthy software house. Well, of course, it's a trustworthy software house. And you've perhaps produced a new cloud-based integrated bespoke business system for a particular customer. But your customer has used some minor issues. Well, all new systems have got minor issues, but they've used this as an excuse not to pay you. All the while, you've been entirely reasonable, but your customer has stopped communicating with you, and they've gone further. They've actually rejected your excellent system. They purported to terminate the contract, and completely unreasonably, they're now suing you. Well, that's one example of a dispute from your side. Let's look at another dispute, another example. This case, you're a completely innocent customer. Now, you had an old but reliable computer system, and you were persuaded by what you now realize was a glib salesman against your better judgment, that a newfangled cloud-based system was going to be the future for you. The new system that you bought had problems from the start. Now, you reported these problems, which you should have done. And every time you reported them, the supplier classified your serious problems as minor. You reported the problems in good faith, and every time you did it, the supplier reported them as minor. Now, was that a reasonable thing to do? Not only you, but all your colleagues agreed that the new system was unusable. So in good faith, you terminated the contract and contacted your lawyers. Now, you won't be surprised to know that these are not two separate disputes. This is one dispute viewed from two different sides. The names have been withheld to protect the innocent. Let's look at another dispute. You founded and you still run a small software house which services a small but quite valuable vertical market. You run it on a family basis, but one of your trusted staff has left and set up in competition. In 6 months, he has produced a product with the equivalent of 10 years software development. So obviously, he's copied your code. Why you need to prove this beggars imagination, because is it not self-evident that is what is done? Take another example. You're a developer. You used to work for this appalling behind-the-times software house. You left to set up on your own, produced a new software product using new techniques to service the target vertical market properly. Your old employer, who was running his company on a dreadful behind-the-times basis, is now trying to stifle proper competition. Is it not absolutely apparent that you are in the right? Once again, names have been withheld to protect everybody. I would suggest that these cases and many others have a series of aspects. There is the legal aspect to such disputes, the contract, the termination of the contract, the employment aspect in the employment case. There are the technical aspects. If there are problems with the systems, well, are there problems with the system? What is the extent of the problems with the system? What is, if you are an expert looking at it, are they serious or are they not serious? If there are allegations of software copying, was the software copying or was there not software copying? But there is another aspect to cases of this sort. There is the commitment of the parties. The parties will tend to be convinced that they are in the right. They may not want to be included in the dispute, but they're likely to be convinced that they are in the right. Let's move on a bit. The case is now with your organization's legal advisors. Your legal advisors say they need an IT expert witness to deal with the technical aspects of the case. Now, your reaction as a committed employee very naturally might be, I'm an IT professional. I understand the technical aspects of the organization's arguments. In fact, you might even have advised in the preparation of the case. I share the commitment to the organization's cause. I'm committed just as much as the organization is committed. And I can argue the organization's case better than any outsider. I should be the organization's expert witness. It's a very natural reaction. But is this right in law? So let's look at the law. Let's look, in fact, at the leading case, which really summarized the law up to now. And the leading case is one called the Icarian Reefer, where the judge, Judge Cresswell, laid down 7 principles for expert evidence. Icarian Reef is a very interesting case. It's actually a case of a ship that was sunk, where there were expert witnesses on both sides who didn't act independently at all, but argued, in fact, advocated the cases for their side, which they really shouldn't have done. There's another interesting aspect of this case. It's well known for these 7 principles for expert evidence. What's often forgotten about this case is that it was appealed. And every part of Judge Cresswell's findings were actually reversed on appeal. So should you ever meet Peter Cresswell, as he is, and you might well do, he's still active in arbitration and in fact in training. It's a very well known legal circles in London. Don't mention the Icarian Reefer. We turn to the first 2 of those principles. This is where the bulk is. These first 2 principles need some explanation, but they are worth the effort. The expert has got to demonstrate integrity, independence, and impartiality. The expert's job is to assist the court. The expert should not advocate for the party instructing them, which is difficult because the expert is also being paid by that party. It's the lawyer's job to advocate, not the experts. The expert's overriding duty is the court. Now, if we think back to our imaginary employed IT professional who is committed, he said, at this point, he is committed to the party who employs him. It would be very difficult for that IT professional to act as an independent expert assisting the court. Expert witnesses provide evidence of their opinion as testifying experts. Now, I'm going to say a little bit more about this. What does it mean to say expert witnesses provide evidence of their opinion? The law recognizes ordinary witnesses who give evidence in their testimony as testifying witnesses of fact. They say, for example, the equipment was delivered on this date, or I saw this happen. And they also recognize expert witnesses who give evidence of opinion. For example, in my opinion, based on the documentary and other examinations of analyses I've carried out, as detailed in my report, the software was insufficiently complete on that date for acceptance testing. Now, in popular discussion, people will say, well, that's only an opinion. I want facts. But in court evidence, it's the other way around. Factual evidence is things like evidence of identification, which is the most unreliable evidence it is. The valuable evidence is opinion evidence because it can only be given by experts. Experts who've studied the evidence, considered the evidence, and argued from evidence through their expert analysis to an expert conclusion. Expert evidence is evidence of opinion. Now, I've talked so far about experts who are giving evidence, testifying experts. Experts can also act as advisors. There are various names for this. Shadow experts, consulting experts, the Americans say. They advise a party on technical matters, but they don't write reports for the court. They don't give evidence or testimony in court. Expert advisors are not subject to these principles, to these rules. They act behind the scenes of advisors, which is why they're called shadow experts. Expert witnesses are subject to these principles. Expert advisors are not. If we move on to the next principle, an expert witness should state the facts or assumptions on which their opinion is based. It may sound obvious, it isn't obvious at all. When you're instructed as an expert witness, the solicitors will ask you to write a report giving your opinion on certain questions, and they may ask you to assume certain facts. You will derive your opinions from a series of facts, and you must not ignore any facts that are inconvenient for your clients. Those facts will be facts that you're asked to assume, facts that you may know from your specialist knowledge, and the results of tests. The results of tests are sometimes called forensic evidence. The court may not agree with your version of facts. Court may conclude that the facts are different. And obviously, if the court thinks the facts are different, they won't agree with your conclusions. People quite often ask, well, will the court disagree with your conclusions? And this does happen. Well, obviously, it happened in the case of the Icarian Reefer because the parties disagreed. Two sets of experts didn't agree on the facts. One of the difficulties with our system is that it isn't required that the two parties are asked to assume the same facts, and they also aren't required to make measurements or tests in the same way. So they can work on separate sets of facts. They don't have to agree the facts on which they're drawing conclusions. Less of a problem in our area of IT than in other areas, but it can be a problem. An expert witness should make it clear when a particular question or issue falls outside their expertise. Now, in order to act as an expert in the court, incidentally, lawyers use the word expert. We will normally refer to being an expert witness. To act as an expert, you must have specialist knowledge through education, through experience or training, which is useful to the court, and it's the court that makes that decision. And just a little bit about what that means. The court does not expect you or even want you to be the world's leading expert. It's more important that you can express yourself in clear English and present a reasoned argument from facts to conclusion. But you must not stray outside your own area of expertise. Now, I'm not going to emphasize this, but it is extremely important, and it's much easier to do, much easier to stray outside your area of expertise than it might seem. And people have often come astray on this point. There are three more principles. I'm going to skip over these last three because this is an introductory session and I don't want to take too long. These ones are relatively straightforward, though you can go into them at great length. Although these principles were enunciated in the case of the Icarian Reefer, they're now embedded in civil procedure rules as Part 35, which you can read online. They're embedded in Part 19 of the criminal procedure rules. There have been various changes and additions, but they haven't changed the principles very much. Most recent changes have been directed to getting as much agreement as possible in expert evidence as possible before the court hearing. What's very interesting is that similar rules have been adopted in most common law jurisdictions throughout the world. Throughout the world, a lot of work has been done in Australia, Singapore, Canada. The general principles have been generally agreed throughout the common law jurisdictions. Well, I've talked about law. What do experts need to know about law? Well, experts do not need to understand the legal arguments in the case. That's for the lawyers to deal with. But they do need to understand their duties under the civil procedure rules, if it's a civil case, criminal procedure rules if it's a criminal case, and so on for other forms, family, for example. They do need to know how to write a CPR compliant report. Now, there are, as part of the civil procedure rules, there are certain rules as to what must be in a report and how the report needs to be laid out. Go and read the civil procedure rules, that will tell you what to do. You also need to know how to give evidence in court. Not that many cases come to court. Usually cases are settled before they reach court, but some do go to court, and you need to know how to give evidence, and that's a matter of training. Cross-examination can be vicious, and it's better to do some training before you get to court. The BCS does not run training itself because IT is not a major area for expert witness work. But the BCS has always recognized two professional bodies for expert witnesses. First is the Academy of Experts, of which I am a past chairman, which runs training courses and supports its members as expert witnesses. And the Expert Witness Institute, obviously because both bodies are training people in the same principles, the civil and criminal procedure rules. They have very similar, they're supporting members to do much the same work. I did ask the Academy of Experts if they provide a discount for any of you who wish to do their training course on the grounds that you've already had this training. After a bit of umming and ahhing, they said they would. Unfortunately, I can't say the same for the Expert Witness Institute, but if you contact the Academy of Experts, you can see what you can get. Both of these bodies are primarily for civil court dispute experts. They will support criminal court experts. I do criminal work, but they are primarily for civil court dispute experts. In criminal prosecution and digital forensics, the recognized bodies are the Chartered Society for Forensic Sciences, and I'd also look at the published work of the Forensic Science Regulator. Now, the emphasis here is rather different. The emphasis has moved from the presentation of opinion to quality management of laboratory forensic work. So it's a very different emphasis. But a lot of very interesting work has been done by both the Charter Society, which is a professional association, and by the Forensic Science Regulator. Forensic Science Regulator is primarily dealing with the work of prosecution, laboratories handling prosecution work, but not only that. Well, if you're still interested in expert witness work, you'll want to know what risks there are in undertaking that work. Well, you might be sued. Expert witnesses are liable to their clients in negligence, and that was established by a case called Jones v. Caney in 2011. If you do not understand your duty as an expert witness, you could be subject to the financial penalty of a wasted costs order. In effect, what that means is that you could be charged for an unnecessary trial. And there's a very recent case in which that was established. more commonly, you could be subject to judicial criticism. Most commonly, that's for acting as an advocate, which, as I've already said, you should not do as an expert witness, or for not acting independently, or more seriously, and this is very serious, for going outside your expertise. And this can have a series of effects. Usually this means you will not be instructed again as an expert witness, but you could be referred to your professional body for professional discipline. Now, in some professions, medicine, for example, and architecture, this could mean the loss of your right to practice in your primary profession. And I don't think that would apply to us, but in other professions, that's a very serious problem. Solution to this, of course, is appropriate training. And I would also strongly recommend membership of one of the expert witness professional bodies, the Academy of Experts, the Expert Witness Institute, and continuous professional development through those bodies. And further, I'd also recommend specialist professional indemnity insurance, because the best of us can make mistakes. Again, if you still want to be involved, well, how do you get started? Well, you may be in special demand. If you have particular knowledge of a specialist application, you may be one of only one or two people who have specialist knowledge of, for example, message broker software, trading systems, particular technology, perhaps, blockchain. If you're not in such a special position, you're going to have to use the traditional means, networking, speaking at conferences, publishing, writing papers, speaking at conferences, and so on. People often ask about working in criminal work. Criminal prosecution work, which is essentially digital forensics, is all done by police forces or by private laboratories on mass contracts. So if you want to work in that area, you've really got to work for one of those organizations. Criminal defense work isn't necessarily done by one of those organizations, but it's mostly done on legal aid, so it's low value work. It's low value, but it's very demanding. You really do have to have experience in that area before you can do it. The work is very demanding. The instructions from the solicitors are usually extremely unhelpful. It's in many ways it's quite different to civil work. It's different. There's a different area of work. It's very interesting, and it has the advantage that you do tend to get into court. But it's well, I always say it has pluses and minuses, but it's an area that you should be cautious about going into. So to sum up, who can be an expert witness? Well, since I'm speaking to mostly BCS members, the answer is that you can, because you have the experience and training that would qualify you to be an expert witness in IT disputes. Are there different roles for experts? Yes, as an expert witness, or as an expert witness giving expert testimony or writing an expert report, which will go to the court, or as an expert advisor, who does not give evidence in court, but assists behind the scenes. An expert advisor, incidentally, might act as an assistant to an expert, a primary expert witness. In a large and complex case, you might have a situation where there are several technical aspects to a case. And an experienced expert witness might not have technical expertise in a particular area and might need a specialist in a particular area to advise on that specific area. And that is actually quite a good way to get started in expert witness work. What is expert evidence? Expert evidence is evidence of opinion. And this is a point that throws a lot of people. Evidence of opinion. Some people say, well, what about tests and measurements? How are they evidence of opinion? Well, yes, they are measurements of facts, but you also have to know how, you have to form a view as to what are the right tests in order to get that factual evidence in the first place. Is expert evidence the same as forensics? Well, I would say that forensic tests produce factual evidence, but that factual evidence needs interpretation. It needs to be explained to the court. You need to say, this test has given this measurement, which means, and as soon as you say something like which means, that's opinion, expert opinion, because it's not their opinion, it's expert opinion. What sorts of cases need expert witnesses? Those where expert evidence assists the court, and it's the court that decides. The parties might want to bring expert witnesses into all sorts of cases, but the court decides. Parties may say to the court, we want to bring 5 experts, and the court may say, well, one expert will do, and only if we think that that will assist the court in reaching its decision. And in fact, the courts have been cutting down on expert evidence in recent years. What does an expert witness do, both before the hearing and in court? Well, in principle, throughout, the expert witnesses helps the court by answering the questions asked, keeping within their expertise. Expanding on that a little bit, in the early stages, the expert witness is given a series of questions by their instructing solicitors and answers those questions in a report. At a later stage, they will, if the case actually goes to court, they will give oral evidence in the witness box and answer questions and from both parties, evidence in chief from their own side and cross-examination from the other side, in order to assist the court in reaching a fair and just resolution of the dispute. Does an expert witness need to know the law? No, that's for the lawyers to know. But they do need to know the procedures and in particular the duties of the expert. They need to know what the expert's job is. What risks are there? Well, there are quite a lot of risks. You need to know what they are, and you need to know how to avoid them. I have mentioned what they are. You need to avoid them by undertaking appropriate training to be an expert witness. And you also need to be insured. And I would not undertake the role without undertaking appropriate training and without taking out appropriate insurance. Does the BCS support its members in this role? It does. Well, through its special interest groups, in particular the Law Special Interest Group, and through its recognition of specialist professional bodies such as the Academy of Experts. And what are the next steps to becoming an expert witness? Well, I have talked about those. And if you want to follow on and take some of those, I wish you the best of luck. It's a very interesting area to practice in. You will come across the most extraordinary cases. You will come across cases where people are utterly committed to their causes, and you will have to use an awful lot of judgment, not only your technical judgment, but you will have to exercise those characteristics of independence, integrity, and impartiality that I've said are so necessary in an expert witness to do the job properly. Now, I've come to the end of my material. As I say, this is only an introductory level for an introduction to how to be an expert witness in IT disputes. And at this point, I'll be happy to take questions.
Nigel, thank you so much. That was very, very interesting and fascinating. Well, yeah, we have a number of questions mailed in earlier and on chat. Chiara, would you like to kick off the first couple of questions?
I'll let you go ahead, David.
Okay, so I'm going to run through the questions, not necessarily in any particular order. Question just come in, one of the last ones. A friend of mine is a US expert. He is routinely challenged to answer an undergrad exam paper in the court as a test of his expertise. Is this common?
American practice and British practice are completely different. Although the American rules are in principle very similar to ours, the American method of selecting and using expert witnesses do not follow our practice at all. Unfortunately, many American lawyers select their expert witnesses. It is common practice in America to require expert witnesses to submit all their previous reports before selecting them. They then select an expert witness who is likely to agree with their party's side, and they then expect an expert witness, if not to act as a hired gun, they expect to have selected one who will be likely to be favorable to their party's side. So that's already undercutting the impartiality and independence of an expert witness before you start. It's then quite usual to provide an ad hominem attack on experts. Experts are just attacked. It's unusual. Expert witnesses are attacked over here, but that level of attack is simply, it's very unusual. And an attack on that basis would be regarded, if a judge allowed it at all, I think it would be regarded as I think it would only be allowed if there was some very deep question as to the experts' qualifications.
Wow, it's a different world over there, isn't it? Next question. Can the same person act as expert advisor to a company and then later act as an expert witness in court?
This is a matter which is often debated. It's considered, it's possible, but it's considered questionable. If you're acting as an expert advisor, you've partially sacrificed your independence. So it's then difficult to go on to act as an independent expert witness. So it is certainly the Academy of Experts recommends that you do not. And I think that's a sound recommendation. It's not totally blocked. But it would be, it presents difficulties for that reason.
Yeah, that makes sense. And that's actually probably covered a couple of the other questions. More of a business type question now. How does an accredited expert witness articulate their availability and obtain requests to engage in UK or EU civil cases? Curious to comprehend how their remuneration or costs are appraised.
Yes. Give me that again, because I'm not sure whether are we asking about
I think it's kind of two ones. Is how do you kind of promote yourself as an expert witness so you can obtain work in UK or EU civil cases, and then how that and how do you work out the payment for that? I think is probably a summary of the question.
Okay. How do you promote yourself? Well, you promote yourself by advertising, which is perfectly proper, and by getting known. The problem with the advertising is that there are a lot of registers which claim to be the leading expert witness register, and they aren't. Traditionally, there were two good registers for expert witnesses. The originally Law Society, then Smith and Maxwell. It's not Smith and Maxwell, someone in Maxwell register, which has closed, and the UK register, which is a very good one. And the registers run by the professional associations, the Academy of Experts, and I believe the Expert Witness Institute also runs one, because those are obviously anyone who's on those registers has been properly tested, and the UK register also ensures that people on that register are properly accredited. People occasionally go to the British Computer Society to find an appropriate expert, and the British Computer Society then goes to the expert witness bodies. So there's a crossover that way. As for payment, when an expert witness is employed, the expert witness has a contract with the solicitors. This is on a civil case. Expert witness is employed, has a contract with the solicitors, and sets a payment rate with the solicitor, and effectively is paid on contract. And the whole business about how to run an expert witness practice is one which is always the most keenly attended part of any course on how to, any introductory course on an expert witness, on being an expert witness. So when you do your your full course on how to be an expert witness, that is the part that you will pay the greatest attention to. Traditionally, the solicitor was liable to pay you your fee. Solicitors have been gradually slipping out of that requirement for years and years, but you basically have to make sure that your contract with the solicitor is sound, and there is various advice available as to how to do that. Most most instructions are paid on a per hour basis. So you would set an hourly rate and be paid for the hours worked. But there are other ways of doing it. Flat rate, for example. There are various things you mustn't do. You must not be paid on a results basis. You mustn't, for example, agree to be paid a different amount depending on the result of the trial, because that would give you a financial interest in the result, and then you wouldn't be independent.
Yeah, that makes sense. Yeah, another question we've got in, I'm going to slightly modify it, but it's, do you know of any significant demand for expert witnesses in the area of data protection? And maybe we could extend that. Are there any particular areas where expert witnesses are in demand, if that isn't the case?
I know there is some, because I was asked to work in that area, but it's not my area, so I couldn't take the work. I think the difficulty there is that expert witnesses work in disputes that come to court, and where is a data protection dispute going to come to court?
Yeah, I think we're probably still waiting on some of these potential outcomes at the moment.
One of the Yes, sorry,
that's what I was going to suggest, that, you know, it's often kind of a matter, isn't it, of interpretation of whether, you know, software was coded properly or the right security measures were in place, etc., etc.
Yes. I haven't seen any of those cases coming to court, because they wouldn't necessarily come to court. They might well get settled before, which means there could well be a very great deal of expert witness work done earlier. But normally there would be investigatory work done as well. So there might well be investigatory work done first, and then opinions prepared. Investigators don't normally, well, may or may not become expert witnesses, but they wouldn't necessarily give opinion evidence. So you might well have a situation where there was a breach, for example. The people investigating the breach might or might not give opinion evidence.
Yeah, that makes sense. I've got a question. It's slightly kind of along these lines as well. What about being an expert advisor rather than an expert witness, working on a no-win, no-fee basis? So the work can be assessed and priced, leaving it to an expert to assess and test the evidence for the barrister to argue.
Well, if you're working as an expert advisor, there are no restrictions at all on what you can do, because you're not, you can work on whatever basis you want, because you're not giving evidence to the court. You don't have to be independent. You don't have to. You can be an employee. You can be utterly committed. There are no restrictions at all as an expert advisor. However, it's probably best to remember that whatever advice you give may also feed into whatever the advice the lawyers are giving. If you give advice that causes the party to think their case is stronger than it is, then they may go ahead with a case which really isn't very strong at all.
Yeah, that makes a lot of sense. Another question we've got, is an expert witness always an independent, or can he be hired from an external company, I guess, of expert witnesses?
Now this is there are expert witnesses are appointed and nominated as individuals, but they very commonly work for organizations, often consultancies. In engineering, for example, most expert witnesses work for engineering consultancies, and the person who gives the evidence is the head of a team. So in that case, you might have a team of 10 people working on the case, and the person who gives evidence might be either the head of the team or a nominated person within the team who presents the report, listing all the people in the team who've done the various pieces of work, but one person gives the evidence. That also happens in IT cases where it's appropriate. And it sometimes happens as well that there are teams, there are well-known consultancy firms in IT disputes where cases are given to particular people. In some cases, they may on occasions have associates who come in to do particular cases as well. That is quite a common way of working. But the person who gives evidence as themselves.
Right, not as a company. Yeah.
The report may well say Fred Bloggs of Consultancy Co Limited, but they give evidence. The person gives evidence.
So it's the person who's sort of directly responsible for that evidence.
Yes.
Another question just in: how common is it for an expert witness to be sued for negligence? Could the expert end up with a large claim against them, even if they've got professional indemnity insurance?
It's extremely rare. When the case of Jones v. Caney was decided by the Supreme Court, the big fear wasn't that there would be a lot of successful claims, but that there would be a lot of disgruntled parties who would go around suing everybody they could think of. This hasn't happened.
Interesting. And another question: how frequent do expert witnesses disagree in a specific matter?
This is a very interesting question, and it's a question. It's a question which I would like to layer. If you remember, I said that one of the problems really the legal system has, is that the experts are not necessarily given the same facts or asked the same questions. Now, if we just think about the processes, I suppose we've got a relatively simple dispute. We've got two parties, each appoints an expert. There's actually no system for ensuring that each expert is given the same information and asked the same questions. So each expert will write their report. There's then an exchange of reports. So each expert's now read the other expert's report. But at this stage, they may have been answering different questions on different assumptions.
Mm-hmm.
So they're putting this together, and then they say, so at this point, what are they agreeing and disagreeing on? Now, there is a mechanism in place for what the courts don't want is for two experts to come to the court and be asked a lot of highly technical questions, which the court the judge doesn't understand, and disagree about them. They don't want that. It's very common to have, you might start out with 30, 40, 50 questions. And if you can actually tie down these questions, the experts might agree on most of them, if you can actually agree what the questions are. As far as possible, the court will try to get a list of agreed questions and then put the experts together, not in the court, expert to expert, get the experts to discuss them. If they can do that, and there's a big if there, you very often find the great majority of these questions can be agreed. The answers, the experts will agree on a great majority of these questions. Doesn't always happen.
Interesting. Yeah. So we just had another question, which I think follows on. It says, is there a move towards courts wanting to appoint a joint expert rather than each side appointing an expert separately?
One of the reforms that was made a few years ago, one of the Wolf Report reforms, was that on low value cases, the court can insist that a single joint expert is appointed. Now, in France and Germany, for example, the experts aren't appointed by the parties, they're appointed by the court. There's one expert, the court appoints the expert, and the court then gets the report from the expert and makes the decisions based on that single report. A single joint expert is not like that. A single joint expert is jointly appointed by the two parties. So it's like a party appointed expert, except there's only one expert appointed by both parties. The parties then ask questions to the single joint expert, who is then responsible to both of them. Now, if they ask him the same questions, he or she can then go off and look at the evidence and reach a conclusion. The problem tends to arise if they ask different questions. And this does happen. You can get two parties asking entirely different sets of questions, of it's slanted to what they want the answers to be. Courts don't like this, of course, because it takes away the whole point of the exercise. The parties don't like single joint experts because they think they can't manipulate them. It's the real reason. But experts try not to be manipulated. Single joint experts have terrible trouble. And you can get a situation where a single joint expert will present a report and will then be cross-examined fiercely by both sides. But neither side likes the report, and both will have a go at them. But it works reasonably well for low-value cases, but it's not adopted in high-value cases.
Interesting.
Nigel, while you were talking and answering the questions, interestingly, delegates started typing sort of add-on ideas. So I just wanted to run a couple past you. You know, they're not really questions, but they're just interacting with your points. So, for example, when we were discussing areas in which there's a demand for expert witnesses and whether data protection would be one, I think interestingly we have Deborah saying, well, information tribunals or civil cases where claiming compensation from a data controller could be places to look for data protection experts. And I am inclined to agree with Deborah. I don't know if you have any views. Information tribunals, have they ever been on your radar? Have you got experience there? Nigel?
I haven't, but I would have thought that would be better handled by a different mechanism. In construction, they have expert panels, which the experts on those panels are actually acting effectively as judges, who look at a problem. It's usually a problem rather than a case. Assess it and reach an assessment and present an award of some sort. Usually not a legally binding award, but it's although it's not legally binding, it's very rarely appealed. I would have thought that something like that would be a better approach.
Okay, thank
It's
you.
a lot cheaper.
Wendell also added on to that same point, the case of data breaches seem more likely where negligence of the controller is in dispute. So data breaches definitely seem to be a common perception. I don't know if you have views or experience in that. High profile or even...
Yes. Difficult. Well, let's run through some of the difficulties there. How are you going to get hold of the evidence?
Okay. Difficulties. Point taken.
What are the difficulties in here? If we're talking about here about expert witnesses working in court cases. So in order for this to happen, you've got to have two parties. So obviously one party here is the company where the data breaches happened. Who's the other party?
Yes, it has to be a consumer organization or
yes,
a sort of class action type.
Class action, and they've got to have enough money to appoint. They've got to have enough money to appoint experts, and they've also got to have some means of getting hold of all the evidence. Meanwhile, presumably the party where the data breach has occurred has done everything they can to block the data breach. So I'm just one. So whatever analysis is taking place is presumably going to be done on a documents only basis.
Fantastic.
I wouldn't have thought this was a good approach.
Wonderful. Okay, I mean, it's a good explanation. I think it warrants more thinking. Deborah has come back with another suggestion, and obviously Deborah has been working in Information Tribunal, I can tell. Deborah, maybe you should carry on this conversation. She says, information tribunals have a bench of 3 people, but parties make representation and present their cases, especially if we have oral hearings, so very much like a court or employment tribunal. I think this really doesn't warrant an answer. It's just thank you for that, Deborah. Wendell also joins in and says class action lawsuits, and he makes a suggestion, perhaps an auditor from the ICO. Good point. Fintan suggests could be a dispute between a service user and a service provider, data control and data processor. So thank you for all these suggestions. I think I want to go back to one of the earlier questions, and we have our very own Stephen Castell, who is also a committee member, a fellow committee for the specialist group, law specialist group. And it relates to the matter of being an expert advisor as well as an expert witness. And I'm inclined to give Stephen the floor because obviously Stephen has a fair amount of experience. It's not really a question, it's just joining in with his own experience. So Stephen, I am unmuting you if you want to put your point across. The floor is yours.
I see my microphone is going to do. Thank you, Chair. Nigel, it was just to add a couple of other comments to your otherwise superb presentation, of course. Just to say that, to make it clear, that being an expert advisor to a company and a project, being involved with it, does not legally strictly rule anybody out from being an expert witness. that anybody can be an expert witness. There is no pre-qualification that either the court asks for or indeed either the parties ask for. The key thing is, if you are promoting yourself and representing yourself as an expert witness, then you will be gauged by that and attacked on that basis. And if you have been involved as an advisor, then that will be taken into account clearly, and often the court will take it quite severely into account when assessing the weight and relevance of your opinion evidence. And one might also say, practically speaking, if you are a previous advisor, if you've been involved with a very project which is in dispute or issue in dispute, you may have already been asked to swear or witness a fact statement by the lawyers involved. Now, if so, that would rather and usually rule you out also giving independent expert opinion evidence. But again, not necessarily so. There could be some issues in the case where your expertise is worthwhile having an opinion from, but you haven't necessarily been intimately involved in it's a fact. So it's not quite as clear cut as it may seem at first sight. I agree with you, it is very unusual to have expert advisors or previous consultants in projects, certainly, also to swear an independent expert witness report.
Thank you.
Yeah, so that was that.
Stephen, I have to advise that you sound as though you're talking from a submarine. So having had the benefit of having a note of your answer, I'll try and repeat it because it really was hard to hear all that you said. So Stephen is claiming that being an expert advisor strictly does not rule anybody out from being an expert witness, but you must make sure to disclose your previous connection with the relevant party in the dispute, and you must do this anyway. The court will take this into account when assessing the weight and relevance of your opinion evidence. Plus, if you have been an advisor previously, you may be asked to swear a witness of fact statement. If so, that would rather rule you out of also giving independent expert opinion evidence. So I think we have got to the bottom of this. Stephen also reminds us that anybody should be very careful of working on a no-win, no-fee basis and make sure that you check your professional indemnity insurance for that clause. They probably will not cover you if you charge on the basis of a no-win, no-fee.
Those are very much textbook answers. They're excellent summaries.
Gosh, thank you. Wonderful. It's we have one of the rare cases where two expert witnesses agree. There you go. One last point, which is more housekeeping than substance. One of the delegates is asking if it's possible for BCS to produce some sort of certificate of attendance for this event, so that they can then either claim the discount that Nigel was discussing earlier, or to submit it as evidence for any special treatment, special price for membership bodies. So this is from Alexis. I think the short answer is that no, we don't. Unfortunately, BCS law does not have the power to issue attendance certificates, although it's a very good idea. We should probably discuss this and think carefully how to credentialize attendance at our events. I don't think there's anything wrong in suggesting, however, Nigel, that you and Alexis maybe get in touch. Alexis might write an email to Nigel. We've provided Nigel's email in the chat, so please scroll the chat, and the very first answer to the chat is Nigel's email. And I can vouch for the fact that Alexis has been attending throughout and has been sort of present and right until the end with the questions. Definitely that is something we're not sort of set out to do, but we will do our best to help if you need us to certify something.
There'll be no problem there.
Oh yes, an informal email. Mm-hmm.
I see there's an interesting question in the original, one of the early questions. If I can take that one. do companies' internal teams like tech, audit, compliance, security ever get called as expert witnesses? For example, in the case of internal employee fraud, for example. Now that's a very interesting question. Because if you get, for example, a case of internal employee fraud, usually the only people who can produce, for example, computer logs will be the internal company staff. And the only people who can interpret those logs will be the internal company staff. So the reports that they produce have got a very, very interesting status. They can't be independent because they're employees, but they're a bit more than witness of fact, and they have a rather curious status. They really are, they're halfway between witness of fact and opinion evidence. And the law just has to take them as such. So the answer to that question is, well, sometimes you get a situation where there is no clear answer. Certainly, they fall into a rather grey area where they're not quite expert witnesses because they're not independent, and they're not quite witnesses of fact because they're also interpreting factual evidence. That's from Cheryl Tan, who's asked a very difficult question.
Okay, thank you very much. I think Deborah has come back for us with a comment, really not really a question. Status of employees is where the post office went wrong with the prosecution of their Horizon system. I don't know if you have any comments on that, Nigel, but
I wondered if anyone was going to come up with that one. I've been trying to read the judgment in that case. The employees who gave evidence in that case were heavily criticised by the judge, but they weren't giving evidence as expert witnesses. They weren't criticised. Interestingly, they weren't criticised on that basis. They were criticised for not giving. They were criticised for not answering the questions they were asked. It's a very interesting judgment if you read it. Quite a few of there were quite a few employees who were called to give evidence, and they were asked a whole series of questions, and they were mostly criticised because they gave spun answers, PR answers, rather than answering the questions they were asked. And the people who did that least, interestingly enough, were the more technical people. It's one of these cases where a company put managers and PR people in to answer what should have been technical questions to some extent. It's a very interesting judgment to read. You do get this sometimes. I've been involved in a number of cases where there were technical issues, and there was a company involved, and the company put a manager who didn't really have technical qualifications in to give technical evidence. And the lawyers didn't pick it up. I think there is a weakness in legal education that lawyers are actually very bad at recognizing what is and what isn't expert evidence. And one thing that experts can do is pick out what purported expert evidence that isn't expert evidence. And lawyers can't. You would think that lawyers could do this, and they can't. Experts can. It's very, very odd. Very, very odd.
Great. Thank you so much, Nigel. I think that was amazingly informative and very detailed, because I think we discussed earlier that this was really just a primer, and I think we've kind of gone beyond that in some areas. So thank you so much for running through this, and we hopefully will have you back again shortly. So I'd like to thank Chiara and Nigel. Thank you so much.
Pleasure.
Thank you, everybody. Just a reminder that if you want to be on our mailing list and receive notification, please sign up to groups@bcs.uk. In the header, just say, I want to be on the BCS law list, and that will be passed on to us, and hopefully you should never miss a beat. It was great. And David, I'll let you wrap up. Thank you, Nigel. That was really good. I enjoyed that immensely. David, over to you.
That was great. That's great. Thank you so much, everybody. And I think we'll bring this meeting to an end. Thank you.